I was asked to, thank you, a little while, but I was asked to start by talking a little bit about the judge's role, and let me do that, and then I'll have a couple of things to say about places where I think some of these problems can be addressed. The first question that I have here is, when a child comes before you and was found guilty, how did you go about deciding on the sentence? Well, you talk to them. One, in almost every case, you get what's called a predisposition report. One of the first rules of juvenile law is we don't call anything by its right name. Nothing is called a crime, it's called a delinquency. Nothing is called a trial, it's called an adjudicatory hearing. Nothing is called a sentence, it's called a disposition. They're different words, but they largely mean exactly the same thing that they do in the adult division of the court. But you'll get a report that gives you some information about the child, about the family. Interestingly enough, about 5 years ago, the Department of Juvenile Justice, as a matter of policy, I guess, stopped telling the judges about a child's previous delinquency record in the predisposition report. I frankly don't quite understand the rationale behind that. But that's one of the things that I always wanted to look at. And then it would give you some information about the offense, and then make a recommendation. And then you have a hearing where you listen to the child, listen to the family. More often than I liked, they didn't have much to say. And it bothered me. It particularly bothered me when a child was there in court without anybody from the family. That happened a whole lot more than I liked. And I'll get back to that thought in just a moment. And from there, you look at what's it going to take to change this behavior? What's it going to take to keep this behavior from continuing, from repeating itself? And of course, it makes a whole lot of difference what the charge is. I'll get to back to that in a few minutes too. There are not guidelines in the way that there are in adult criminal, where I am now. You don't have a score sheet that we have, such as we have the Criminal Punishment Code. But the judge does have, in one sense, very limited options, and in another sense, very open, very wide options. The judge's options in a delinquency case are: you put the child on probation, or you send the child to a commitment program. That's it. Now, that makes it sound like it's binary. It isn't entirely, because with probation, the possibilities are almost limitless about what you can do. And you get pretty creative with that if you stay there very long. We do use community service hours. Frankly, we are required to have some punitive aspect of any probationary sentence. That can include something like community service hours. It can include writing an essay. That's got to be something they're required to do that makes them do something more than they would do ordinarily. In terms of remedial or rehabilitative or habilitative aspects of a probation order, there your limits largely are what's available. And we are constrained in a lot of ways by not having the availability to pay for psychological services or counseling services. We've got some, but when I left, and I left June at the end of 2013, it may be that some of the things that I tell you will be a little bit out of date. But again, we have to have a service available. One of the things that's fairly traditional in juvenile court, and it's judges who come there from adult divisions of the criminal court are boggled by it, is that judges are kind of expected to go out and recruit resources. And we did some of that. I did some of that here. Well, be that as it may. I don't want to overrun my time too much. If you do a commitment, my understanding now is that there are only low-risk and high-risk commitments. It used to be that we had actually 5 different levels, one of which didn't involve taking the child out of the home. But they would range from at-home counseling. It looked a lot like probation, except it was called a commitment, to low-risk commitments, which were residential, but which looked more like halfway houses, most of them, or residential facilities. Frequently would have, and most of the levels would have some substance abuse treatment in them, because we had a lot of that. A moderate risk commitment, which looked more like, not a prison, but more like a secure facility. And then high risk and maximum risk. I sent 2 kids to maximum risk in 18 years. I mean, it just almost doesn't happen. Partly because by the time you qualify for maximum risk, usually you're being charged as an adult. But maximum risk requires some pretty serious crimes. High risk requires relatively serious stuff, a bunch of them. And those look more like prisons. Now I'm told it's either low risk, which is in the community, or it's high risk. And that brings me to the next question, which is, if you send a kid to a residential program, does the judge have any choice where the child goes? And the answer is no. That decision is made by the Department of Juvenile Justice. The theory behind that, I think, is that DJJ is charged with having the expertise to put kids in the places that are best suited for that kid. Whether that works out in practice or not is an issue I'm not prepared to talk about here tonight. But that's the theory. Additionally, the Department of Juvenile Justice is charged with recommending to the judge a restrictiveness level, and the judge is not allowed to differ from that without satisfying a very difficult, I will not go into what the legal requirements are you have to meet. You can find them if you want. In re EAR, those are initials, is the name of the Florida Supreme Court case, or it may be EAR versus state. You can find very, very difficult for a judge to choose a restrictiveness level that is different from what the Department of Juvenile Justice recommends. That said, DJJ much more frequently, at least when I was there, recommended lower level of restrictiveness. When I disagreed with them, I was far more likely to disagree with them by thinking a higher level of restrictiveness was needed. Let's see. Juvenile justice is entirely a creature of statute. The common law does not apply. So if you want to talk about some differences in the legal system, they have to be made by amending Chapter 985 of the Florida statutes, which sets all of the guidelines and policies for the juvenile justice system. Now, a couple of other quick thoughts. The best thing you can do for kids is to keep them out of the juvenile justice system. Now, that to me requires some changes in behaviors. I think over the course of the last, well, I was 18 years there between 1996 and the end of 2013. Over that period of time, several things happened. In the last 10 years, where we were getting 3,000 cases a year in Escambia County, we were under 1,500 the last 2 years I was there. I cannot account for all of that difference. I mean, I don't know whether there were changes in behavior of the kids or changes in behavior of the police, or whether the state attorney made some different charging decisions. It's not accounted for by the civil citation program that came in just as I was leaving, because I'm talking about numbers when I was there. And the civil citation program only started a few months before I left. I don't know what the numbers are now. And whether the civil citation program has changed that, I don't know. I do think probably 90% of the kids who get civil citations now probably would have, even though they had a case number, probably would not have been prosecuted under the previous system. So I'm not sure that in terms of actually prosecuting, the only real difference is now with civil citations you don't have an arrest and a mugshot and an arraignment. But several things I think play into this. One is the two biggest predictors. Whether a kid is going to come back after the first time in the juvenile justice system is first how the family reacts, and whether the family gets involved, and whether the family takes charge, and sets the kids straight. Families can do a whole lot more than anything we've got in the juvenile justice system to do it. And secondly, school attendance. Kids who skip school with any regularity were far more likely to come back with additional charges. And that's entirely apart if the times that we violate their probation because they weren't attending school. We usually did require school attendance. But that, to me, requires some changes, and we've seen some changes in our school system here. Judge Parham and I, who were there together for a number of years, met with the school district under a prior administration, and we didn't see nearly as many suspensions that they would refer in for at least a violation of probation. After that, they stopped suspending, either stopped suspending for minor things, or at least we didn't get them back in juvenile, and that helped. The second thing is, my recommendation would be, let's get something that's an alternative to suspension. It's difficult for me to imagine juvenile probation orders without requiring school attendance, which includes don't get suspended. That doesn't mean everything a kid does wrong at school should result in a suspension. Secondly, if you start by doing something that's an alternative to suspension, so they're not on the streets, they're a lot less likely to get in trouble to begin with. We did that for a while here. There was a short period of time when we had a storefront that kids would get sent to when they were suspended. I honestly don't know what happened to that. But I think that helped a lot in getting kids off the streets or out of their homes where they got in trouble because they weren't in school and were not occupied. Secondly, we got to find a better way to deal with fights. Adolescent boys will fight. And so in growing numbers, much to my surprise, real change between 1990 when I started, I was a juvenile briefly then, and when I left, so were girls. We never saw girls with fights in 1990. In 2013, about as many as we did with the boys. Somewhere along the way, we got to find a way to decriminalize most of that. And frankly, my experience is, apart from the schools, the biggest reason those kids got charged was somebody else in the neighborhood. You get the kid to get beat up and their parents are in talking to the elected state attorney, they're likely to get charges. State attorneys hated prosecuting those things, in my experience. But, you know, there it is. Now, that's part of electing some of these officials. Anyway, I've talked longer than I should have.